Good evening, ladies and gentlemen, excellencies. My name is Renata Oitz. I'm the director of the Comparative Constitutional Law program at Legal Studies, and I would like to welcome you at the 7th annual Marek Nowicki Memorial Lecture. Please be aware that the lecture is being recorded, so if you are unhappy about that, then try to stay out of the camera's line of sight. As many of you may know, CEU celebrates its 20th anniversary year this year. You are aware, if you are from here or from around here, that this is an international interdisciplinary academic community creating and maintaining an open society according to its mission, which did not change since the last 20 years. Legal Studies Department is among the founding departments, and the cooperation of Legal Studies and the Open Society Foundation, which is the sponsor of this lecture series, goes back to the very early days of the foundation of CEU. The Marek Nowicki Memorial Lecture Series mirrors our own commitment to train lawyers and practitioners of human rights and constitutionalism who will become agents of change. The lectures bring to Budapest and to the twin lectures in Warsaw such highly accomplished individuals who stand before us as a testament that what we all crave to achieve is indeed totally possible. The list of previous speakers is humbling. It fills me with great pride that I could be here to listen to these exceptional individuals reflect on the human rights regime as they saw it transform in their own hands. Let me give you the names of previous speakers. We did have here Arthur Cheskalson, the former president of the Constitutional Court of South Africa, Jon Alster, an eminent scholar of constitutional transitions, old and new, Aharon Barak, the former president of the Supreme Court of Israel, Theodore Meron, a judge on the appellate panel for the ICTY and ICTR, then Asma Jahangir, a Pakistani human rights activist, who also happens to be a former special rapporteur for freedom of religion or belief. And last year we had Juan Mendez, who in his latest capacity was a special advisor on crime prevention to the prosecutor of the ICC. Their former lectures are best described as voices of courage, wit, and perseverance from 4 continents, and a shared belief that the protection of human rights on small scale and large makes the world a better place. Tonight we welcome Robert Badinter, an eminent French lawyer, to share his thoughts on European justice. But before his lecture, please let me invite Professor Viktor Oshetinsky, who will tell us about the late Marek Nowicki, in whose honor and memory this lecture series stands.
Good evening. For some of you, I will repeat myself because Marek Nowicki life didn't change since last year too much. But for some of you, it will be new because you are here for the first time. Now, let me make a little comment about the last year's speaker, who was Juan Mendez, who, besides the position that Renata said, he was just shortly before giving lecture appointed the special rapporteur on torture. And that was the first case that special rapporteur on torture was himself had been a victim of torture, because in Argentine, his home country, he was tortured pretty heavily during the dictatorship. And it is not a pattern we want to establish here, Robert. This is not something that we think to do, but it was pretty important. And then when he went on for the lecture in Warsaw, I accompanied him in Warsaw, and we went to see and for a long talk with General Jaruzelski, who introduced martial law in Poland at that time almost 30 years earlier. And it was absolutely fascinating conversation, which was not inimical. It was actually curiosity and open thing of the victim of dictatorship and the perpetrator, who understood the problems, fortunately, as distinct. And actually, Mendes went out saying, you know, that if we if we are to regret something, the Poles, that maybe perhaps you're dictators, you know, but that was just the thing that happened last year. Each year there is something very special, very personal about the lectures. I'm in a small group of 3 people, Arjen Nair, myself, and Andras Shayo, who make the selection process. And each time we think about the people to invite, we think about subjects, topics, and then we meet with them. And it's always an incredible personal experience that is opening up our minds by meeting people, personally listening to and meeting people who really influence our lives, either indirectly through what they do for human rights, justice, constitutional courts, and the social change, but also in very, very personal dimension, because these people are unusual also on the level of relationship. Marek Nowicki also was an unusual person. He was not a lawyer. He was not a constitutional lawyer. He was actually a physicist and astrophysicist. And when he was in his late 20s, because he was a very good physicist, he went for scholarship to Russia near Novosibirsk to Akademgorodok, where they have this physicist center. They had the physicist center, and they lived relatively close, secluded, of course, surveyed by KGB or whatever, and they were mostly drinking and talking about physics and talking in general. And then he recalled that that was the place and the moment when he realized what does it mean to be affluent, to be successful, and not to have freedom, and to be unfree. And actually it's very interesting, because most of the people who became first-generation fighters for human rights in the Soviet Union, in Poland, including Marek Nowicki, were scientists, physicists quite often, mathematicians, astronomers, who saw 2 things, that for their endeavors, freedom is necessary, but also whenever they may have perfect conditions to do science, there is something which is shackles around them. And of course, Andrei Sakharov is another example of a physicist who turned, biggest example perhaps, who turned the human rights activist. Marek Nowicki was one. He returned. He was very much committed to human rights in underground circles that were developing in Poland in the 70s. He was in the group of the so-called mountaineers or climbers that would meet with Czechoslovak counterparts in Śnieżka and other mountains. You know, there is a very funny thing that Havel and this group of people met once, and Havel and the Czechs were bringing backpacks with food. We didn't have much food at that time. And they had, so he had some kielbasa, you know, and food, and a bottle of vodka. And there was a vodka, hunter's vodka, with a painting, with a picture of a hunter. And he said, we failed with socialist with human face, but I brought you some vodka with human face. We can drink this. And they had it. And Marek Nowicki was one of those during Solidarity, and especially when when Solidarity Carnival or Solidarity 16 months became really confrontational. He was in the committee of the Warsaw region of the complaints. Whenever there was complaints about violation of rights, about the abuse of police power or something like that, he would be the one who would bring that complaint and see to it that these complaints will be solved. Then he was arrested and interned like most of the Solidarity leaders. And then in 1982, he was one of the people who created Poland Helsinki Committee. Helsinki Committee was a committee of known intellectuals and known people. It was everywhere. It started with the Moscow-Helsinki group in 1975 after the Helsinki Agreement. I know or not that Helsinki Agreement was actually saying that to Europe, at least to East Central Europe, brought human rights. For 20 years there were pacts in labor, there were works, but no one really gave much attention to that. When I was a young assistant to the professor, and me and students, we were demonstrating in 1968, no one used the word human rights. We were saying that Polish communist government is violating our own communist constitution that did not have any enforcement, but had some promises. 75 with Helsinki Agreement, which was needed for Soviet Union because of the access to technology and the line of credits, etc. There was this part of human rights in which I just want to say it because it's non-known. One sentence added probably by someone in British Home Office changed the world. The sentence was added to the preamble and was saying everyone has a right to know his, at that time it was just his, I would say his or her rights. On that basis, next day, Sakharov and Ludmila Alexeyeva and others created in Moscow Helsinki Committee. We will see that everyone will know what are his or her rights. And that continued, and in Warsaw in 1982, Marek Nowicki was one of the founders. It was, you know, they were harassed, there were a lot of problems, they continued, survived until the changes, and at the point of changes, the Helsinki Committee created Helsinki Foundation for Education of Human Rights. And Marek was the founder of that. And Marek Nowicki was the first director. And Marek Nowicki started doing incredible things outside of Poland. He actually almost single-handedly created broad human rights movement in the Caucasus and in the Central Asia. He was going there. He created a school of human rights that was in Poland in Russian language. They were bringing activists from the countries of Central Asia and Caucasus, and later on this advanced school of human rights that was co-founded by OSI, Ford Foundation and MacArthur Foundation was created that was doing that. And he was doing a lot, you know, sitting with people hours, and he didn't write that much. He wrote some, but he was just talking 2 hours and sharing, and basically his enthusiasm to human rights was contagious. That was in his person. But for the last few years of his life, he was coming back. I was already at the Open Society board, and he was telling, you know, Victor, is it possible? We have one problem. We train these people in Central Asia and Caucasus. They create these human rights organizations. But they can do very little because the best organizations, they want to do something locally. They need $10,000, $20,000. And no one wants to bother to give $10,000, $20,000. Big foundations, governments, they can give you $1 million. They can give 100,000, but to give small grants, 10, 20,000, it's too much bureaucratic work, too much paperwork, etc. No. So could we assure that? And I was banging my head in OSI, other places, and we couldn't. Marek died at the age of 53, died for the lung cancer. He smoked heavily. He really smoked heavily. And he died, and then when he died, we thought in OSI how we can commemorate him. And there were 2 ways. First, the small grant funds was created of $200,000 a year that is distributed to these small groups in Central Asia and Caucasus. And I tell you, they are doing probably the best job because they really are committed. Mostly they give their own work. And this is the fund named by Marek Nowicki. But the second thing between OSI, Helsinki Foundation for Human Rights, and Warsaw University and CU, we created this lecture series. And the lecture series is devoted and has the name of Marek Nowicki, and that's the way of commemorating him. Actually, we will be bringing back, recreating the school, advanced school of human rights for Central Asia, Caucasus, former Soviet Union, and the school now will also have a name of Marek Nowicki. So I just hope that he was very, very nice, fine man. He was meant to talk with, meant to listen to, meant to just, he was like a magician when he was talking about human rights. So I just stop on that, and I will give the floor to Renata to introduce Professor Badinter, and I'm very grateful that you agreed to be the speaker in this series. Thank you for your attention.
Thank you very much. Tonight's speaker, Robert Badinter, is a very prominent French lawyer. He is a former Minister of Justice, a former President of the French Constitutional Council, and until very recently, he was a senator in the French Parliament. He's the author of a dozen books, as you could see on the poster, and he is the master of multiple causes in human rights and criminal justice. Pursuing even one of these achievements would have been a major accomplishment for anyone's life. He started his career as a brave criminal defense attorney, and this is where his cause for the abolition of capital punishment comes from. Over the years, he witnessed more than one authoritarian regime to crumble, and he saw the better and worst of European politics, and ultimately the worst and best of humanity. When he became Minister of Justice of France, he got to oversee the abolition of capital punishment in 1981 for the Mitterrand government. And it is largely his achievement that not only France, but also by today, Europe is free of the death penalty today. During his formidable career, he came to experience the complexities of his commitment to abolition in the context of transitional justice. Because it was during the very same ministerial term of his when the French government sought the extradition of one Klaus Barbie, who was also known as the Butcher of Lyon. Barbie has actually been identified more than a decade before that, but his extradition couldn't be undertaken until in Bolivia, a democratic regime took over from an authoritarian one. So thus, Justice Minister Badinter had to answer the question of what can and what should a justice system do when it faces radical evil and intends to put it on trial after the abolition of capital punishment. What is left? At a personal level, his response was surely affected by his experiences from attending the Eichmann trial in Jerusalem earlier, and also by being the son of a man who perished at the hands of the very Butcher of Lyon in Auschwitz. He also had to account for the fact that such trials are not simply about assigning guilt and innocence, but are also about the identity of a political community where survivors, descendants of perpetrators, as well as of victims, do not have a choice but to carry on with their lives, to coexist peacefully. Thus, when it came to the extradition of Klaus Barbie, Minister Badinter became the architect of a project in justice, as well as in the memory of the Fifth Republic, and in reinstating the memory of the resistance in democratic France through criminal prosecution, decades after the war. Also, he had the sanity and humility to remind that handling grave past injustice is not only about fair prosecution and punishment, but also about forgiveness. In 2001, when another prominent French war criminal, Maurice Papon, was facing prosecution, he was quoted in the New York Times saying that there is a point where humanity must prevail over crime. Papon is just an old man now. To Robert Badinter's most commendable record of public service, the early 1990s added another chapter, when he carried out an EU mandate to oversee the dismantling of the former Socialist Federal Republic of Yugoslavia. This is known as the Badinter Commission, which comprised of 5 West European Constitutional Court presidents, and the commission was chaired by him. It was under his leadership that the commission became famous for its insistence, and I quote, that the republics must afford the members of minorities and ethnic groups all the human rights and fundamental freedoms recognized in international law, including, where appropriate, the right to choose their nationality, end of quote. He continues to be a supporter of the European project, as you will hear from him just shortly. Knowing his work, it is clear that his conception of Europe doesn't halt at the boundaries of the European Union. Just in last April, he participated in a forum in the Ukraine on juvenile justice reform. And he reminded everyone, not just the participants of that forum, but also us, that justice for juveniles is a major moral and democratic issue for all societies. The way the society treats its juveniles is the way these juveniles will treat their society when they become adults. Please welcome Robert Badinter, a most successful lawyer, a relentless advocate of enlightenment, human rights, and justice, who is also one of the last true public intellectuals of a cosmopolitan Europe.
Thank you, my dear colleague, for this welcoming speech. I think my mother would have liked it much. The only problem is that I must confess that now that there's a rather long life already behind me, I must confess I am not a serious man. And all of that is done only because my mother told me, Robert, you will never be a serious man. So I tried my best to satisfy her, but the truth is, in the bottom of my heart, I am not. And when I heard you speak about this, I couldn't help thinking of, I should have taken another subject. Last year in Paris, I realized the long due ambition. It's not the subject of tonight's talk. I realized in the Musée d'Orsay, which is the museum dedicated to 19th century painting, a very well-known museum, a long-time project called Crime et Châtiment, not an unknown title for those who like great literature. Crime et Châtiment, dedicated to the way that great painters for a century had painted, represented crime. Because I always thought, and I still think, that the artist at the very end knows a little bit more about impulsion of human beings, including what we call justice, that legal minds. Maybe I shall come back one day with all my documents and talk about crime and its representation on the field in which I'm working today, which is theater and crime. And it's a very, 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 very fascinating field of research, because if you look at the founding of the dramatic art, the founding fathers of the dramatic art, the Greeks, you'll find everywhere crime, crime, crime. I will call you to see again the Atrides family's story. It's only crime. But tonight I'm not allowed to do that. I choose myself. So I shall be definitely serious. Furthermore, my old companion Victor Ozjatinsky would not, like my mother, say, you have fulfilled the contract if I were not today speaking about a very serious...
Now I waive the contract.
Bon, la défense à la parole. Oui. Today, it will be a very, not, serious is not the right term, important topic that I choose, because I will confess that I am a truly militant of European Union. I say it very, very strongly in order there is no confusion about my own feelings. I have, being a child and a young adolescent, seen the horrors of war during occupied period in France, and after that, I've lived all my life thinking that for us, all of us Europeans, and I stress the all, there is no future but in an always more integrated European Union. The new generation does not realize what has been Europe before the Union and what were the feelings of one to the other, and the nationalistic, always burning flames of passion throwing nations one against the other. Now, it's over, and with all its difficulties, all the harshness it has to meet, I will simply tell you that each of you, I will not say even each of us, each of you, each European must realize that in the world as it is, if we want to still belong to independent, free, democratic countries observing the rule of law, there is no future but in progressing more in European integration. Even with the present financial crisis, even with all the difficulties we meet daily, it's the greatest human enterprise in history, the building of the Union. Always remember, you have the privilege of youth. Always remember that the Union is the only attempt in history where an empire, a greater nation, an empire, a federal nation, will come out from the agreement of the people. Not by the sword, not even by the words, but by agreement and recognition that each of us in this great union has the same importance as all the others. It's a state of law. The union was built on law and is dedicated to law. Turn back to history of Europe. There was only the sword, the armies, the conquest, and the horrors of war, followed by more or less lengthy occupation. All of that is gone, and gone forever, except if the younger generation does not enough realize this most precious gift that has been the only mark and success of my generation. We have failed when the time had occurred for decolonization, but in my generation we have not failed in trying to build a new Europe, forgetting the past, or more exactly, closing the pages of the past and looking only to the future of Europe. Remember, if you drive a car looking at the past, I'm pretty sure you will end up against the tree or the wall. It's the same for nations. If they keep their eye on what has happened, instead of looking further to the future, as the youth should always do, they will make no real progresses. And I speak of progresses, I mean they will go back to the past, and that past will have nothing to envy, but all the reasons to build a new future. Cette partie nécessaire from time to time I shall turn back to my native language. After all, I was trained in it. This introduction to say that tonight I want to present you with a special problem on which I've been working a lot and which is, I think, of the higher interest for the future of the European Union. It's the question, very difficult, of how we can progress towards really a European justice. In order to I would say, put the basis of the discussion on the fundamentals, I shall quote thought expressed by the French thinker and poet Paul Valéry, but which you will find also in Max Weber. When you look at European civilization, which is our common dimension, I say European civilization, you find out that the pillars on which this civilization has been built, those pillars come from three main sources. Weber said that. The first one is Greek philosophy. The second one is Christianism, including its original source in Judaism, what sometimes people call Judeo-Christianism. I think, speaking of Europe, it's more Christian than Judeo-Christianism, but one should not neglect the origin of Christianism in the Jewish book. And the third one, which especially interests me tonight, est-ce que vous m'entendez bien? Or it's all right. Thank you, because otherwise I would have raised the voice. So the third one, which does interest me, above all, the third pillar is Roman law. Roman law, and I would add a fourth pillar, Enlightenment, les Lumières, the 18th century thinkers. Now, why focusing on Roman law? Because, my dear colleagues, all of us, Europeans, lawyers or jurists, are the heirs of distant ancestors or predecessors, whether they were judges, les préteurs, or whether they were jurisconsultes, were all the remote heirs of the great Gaius. All. And I do not have to remind you, speaking in Budapest, a city that I like much, I do not have to remind you that there did exist long ago a jus communis in Europe, a jus communis, a distant ancestor of the European Union legislation. This jus communis, communis says the purist, communis, not with an S, of course, says the one who likes to speak Latin. The jus commune, the expression of direct common law, has been taught in all European universities during the last period of the Middle Age and the early Renaissance. All the professors of the time, thanks to their knowledge, erudition, and also the fact that they had one privilege, they all made their lectures in the same language, perfectly understood by all the students, wherever they were, Latin. Made it easier. You didn't have to retranslate in your mind your words. It was natural to teach in Latin and natural for the students to hear the lecture in Latin, which makes things so easy that, as you know, they went on, the same ones, going from Oxford to Heidelberg, from Krakow to the Sorbonne, and from Siena to Bologna, so too close, or even here. Those were glorious times. Glorious times when you saw in the Paris University, La Sorbonne, a German chancellor, and nobody found that strange. They traveled by mule, and they met the same or almost the same students when they arrived. We do almost the same, my friend, but using the jet and speaking one language now, which I have to use, English. Sometimes I wonder, does the new Latin that we speak, wait, maybe you do it perfectly, does the new Latin language that you hear in the Brussels Parliament, in the corridors, if not in the theater, is it really English? My English colleagues always tell me, that strange language, Robert, that you speak, is it really, in your opinion, English? Or is it something of your invention? Well, not everybody is due or committed to become Shakespeare. So I do my best, as all the colleagues do. But nevertheless, I go back to the ancestors. We have, as I say, had these old jus commune. And if I stick to it for a second, on the 15th century, if you look at the great Saint-Empire Romain Germanique, you notice that jus communis did exist all over the empire. They had very weak institutions, but they had a very strong common cultural, legal basis. And on this, they have built a civilization which unfortunately did not turn out too well for too long. Anyhow, I shall say, leave aside now a second this European emigrant. I don't think we have, as I said, to regret the old days. Too much war, fratricide, too many imperialism, too many crimes against humanity has been the mark of Europe. But, and then I come to the subject. Today, the European Union is what? Speaking in terms of law, it's a union of sovereign states cooperating in a difficult ensemble, tied together by treaties and a common legislation. Certainly not the easiest way or the clearer thought of constitutionalists. Napoleon, who, as everybody knows, was at the same time a soldier, and being a Mediterranean and Corsican origin, he loved to take part into legal discussion. Napoleon, immediately after the coup d'etat, had a long discussion with the greatest jurisconsult of France, namely Sieyès, who had a project of constitution to nothing to be compared with. He worked for that on 10 years. And the Sieyès came, presented him the constitution, and at the end of the discussion, Bonaparte, he was still Bonaparte, said to Sieyès, all of that is very interesting, but you see, a constitution, in order to work, should be short, and obscure. This political remark, for the second part, applies to the European Union institution. I will not call it yet a constitution, but certainly not the first part. So, working on that, I shall remind you that we are living in the European Union on a strange paradox. We have a union, we have the treaties, we have enlarging each year European legislation, we have European jurisdictions, and we should have much gratitude for these two great institutions, one in Strasbourg, which does not belong to the Union, but is dear to our hearts, Conseil de l'Europe, mais let's have a special dedication to the European Court of Human Rights and the Court of Luxembourg. So we have European jurisdiction. In fact, if you do consider the 50 years elapsed, there is no jurisdiction which has done so much for so many in terms of human rights as the European Court of Human Rights of Strasbourg. And if we, Europeans, and I stress it strongly, have the privilege of living on a continent, 47 states in the Council of Europe, 27 in the Union, but 47. In a continent where fundamental human rights and freedoms are better guaranteed and respected than anywhere else, we owe it to these two jurisdictions, and especially to the Strasbourg Court. I stress it because it's an international jurisdiction, a transnational jurisdiction, not a national jurisdiction. Luxembourg will leave it aside. I shall come back to it afterwards. But if we have rule of law, if we have common legislation, if we have European jurisdictions, we don't have European justice in the Union. We don't. We have an entangled system of national jurisdiction interpreting under the control of course, the Luxembourg Court, the European legislation as applied by the national jurisdiction. But what is justice? Which is an harmonious structure of jurisdiction, all working according to the same principles and ending up by guaranteeing to the various comment on dit justiciable en anglais? Justiciable in English.
Justiciable.
Justiciable? Are you sure? I wonder. Anyhow, you have understood. Les justiciables, the same guarantees, that system does not exist yet. Alors, there is the question of tonight's observations. Why? After all, we have common institutions, the Cour de Luxembourg, la Commission. As I say, we have laws, European laws, I shall go back to it, but we don't have une justice européenne. I see reasons to it. The first one, and there you will find the constant conflict among Europeans about the European Union. On one hand, you have to keep in mind that the power of rendering justice is the mark, the imperium of the political power. It's not without reason that you see, I go back to my painting love, in the paintings or representation of former kings or emperors, what is called the sword of justice, l'épée de justice in their right hand, which means that you are a king or a sovereign only if you are the one who can decide the case at the very end. Today it's the people represented by the judges, but you must keep in mind the origin. C'est l'expression même, the expression of the power, le pouvoir judiciaire. And in the old French monarchy, there was a rule. The King of France used to come to the Parliament of Paris when there was some resistance about registering a decision he has taken. They had the right to say, we don't think this is fit with the fundamental principles of the French kingdom. And then the king came, or the chancellor, and reminded them that le pouvoir de juger, the power to judge, est la marque du souverain lui-même, is the mark of the sovereign itself. And they render justice only under its name and by delegation of its will. And therefore, they should sign. So they signed. That was the end of the session. But this reminds very much, very strongly in the spirit. Sovereignty is tied up with the judicial power, and same thing, judicial power is an expression of sovereignty. Two, the judges, the legal people themselves. They are, damn it, conservative to the core. Not only because they keep wigs or strange clothing, or they love gowns or hats. They are conservative to the core because they are the unique human species who works looking backward. The culture of precedent, I remember a discussion I had in Oxford at that time. A common law based on precedent means nothing else than at the very end, I looked the way my grandfather judged, and I came back and said, ha ha, this is the answer. No, the answer is what we find out to be the answer, not what our grandfather said, that is the right answer. Le culte du précédent is mortal. Mais I must say that in the new European generation, I have seen a more audacious spirit, and that altogether now we could consider that law et le droit is merveilleuse phrase. Le droit est la plus extrême exercice de l'imagination. And I think it's right. Imagination has taken power among the jurists. But the tradition is not in this sense. That explains sovereignty tradition and expression in terms of justice, plus the conservative spirit. Why? Why? In the European Union, there are a strong, strong resistance to the idea of going always further towards a European justice, and more or less a feeling that cooperation is all right, but fusion and unification is going too far. Still, even if this expression is notably prevalent in England, even if the English lawyers have done so good for us in the past 2 decades in Strasbourg and Luxembourg, I would say that we, I mean the ones who fight to precisely create a European justice, un espace européen de justice, une justice réellement européenne, we have for us, on our side, the elements of victory. The conservative are due to lose. The progressive are due to win. Why? Mes amis, la force des choses. La force des choses, said a famous French revolutionary who ended up, as all did at the time, in the guillotine, Saint-Just, la force des choses nous contraignit d'aller plus loin. La force des choses compelled us to go further. That's where we wanted to go. That was true for him, not for justice. Because, just think, what is today the reality of crime in Europe? What is it? I'm speaking of the most dangerous threats against the security of the European citizen everywhere. It's not the petty thief. It's organized crime. And what is organized crime in Europe if not a transnational enterprise? You do not have, whatever the field of organized crime is, human trafficking or international corruption or even the traffic of work of art. Not to speak of terrorism, you always find out at the end international organization, usually known by the Italian term of mafia. Mafias are a threat, a defiance to all of us in Europe. And borders and national laws and exequaturs and all which goes with the past sovereignties of each law in each country, it's no protection for the European citizen. It's protection for the mafiosi, who, by the way, always has the best lawyers to the services. So they use it properly. And that is not to be accepted. We cannot accept that drug trafficking or human beings trafficking or terrorism get a better hand by keeping one national justice fighting against them by side with another when they work on a united basis. That is the first reason why. La force des choses will bring it together, and the path followed proves it. The second, in this time, the field of personal conflicts, the one occurs between private citizens in the family or the matrimonial life, more and more, fortunately, transnational marriage bring more and more questions of transnational law when it comes to divorce or when it comes to the custody of the children. And this is not an easy field to settle. Again, there, also the separate justices of Europe, even through cooperation, are not satisfactory enough. Same for, after all, what's the heart of the European Union? The market. More and more exchanges between more and more economical units means necessarily more and more conflicts, including labor conflicts. And the only answer is to have same law and a European justice. Otherwise, much time wasted, much money spent, and less efficient results. So, as I say, it will come because it's desirable for the European citizens themselves. À partir de là, history, brief history of the construction of this field, of the progress made in the field for effective judicial action, is interesting to follow. I will be quite brief about it. The first time that we had a hint to let's make a European justice space for all Europeans, it was tied up with the rise of terrorism. C'est intéressant because we have had the same progress with the 2001 international terrorism progress. That was in the hard years of the 70s. Some of you might remind what was occurring in Western Europe, the Brothers Bond in Germany, the Red Brigades in Italy, in Spain, ITA, in England, IRA. In France, we had some amateurs called Action Directe, fortunately only amateurs, but it's already too much. Then resistance was necessary, and le président Giscard d'Estaing proposed a convention on mutual assistance in criminal matters. It failed. The Dutch didn't want to accept it. Confession, in 1982, moi-même, the humble servant, being at that time in office, presented to the Conseil des Ministres, in Luxembourg, a project, lovely one, a beautiful, beautiful structure of a European criminal court, which had to judge terrorists if, for many reasons, they were not judged in their own country, they had fled, but were in Europe, and the country in which they were didn't want to judge them. Asile politique was a very difficult. So simple. They should be judged. Remember the old axiom, dare o giudicare, you don't give, you don't judge. We shall have a European court, and nobody can say that this will not be a strong and effective and a rule of law court. It was absolute stupefaction. My colleagues look at me as if I were crazy. What did I talk about? A European criminal court? Who wanted a European criminal court to judge terrorists even if they found themselves at the very end not being judged at all, not being tried at all? No, time had not come yet. I noticed it for the building of the International Tribunal in Yugoslavia, where I got 20 years afterwards my revenge, la Cour Pénale Internationale, which is certainly the greatest step made in terms of law since the Second World War. Alors, after that, we started really to deal seriously with the matters with the Maastricht Treaty. Maastricht Treaty, on le sait, you find there the appearance of the idea of judicial rationalized cooperation. 1996, magistrat de liaison. That doesn't say anything to anybody. A magistrat de liaison are judges judge or magistrate from one country of the Union sent over to increase cooperation with another state of the Union and who works at the Ministry of Justice of the other state. This, you built a réseau which is useful to promote cooperation. But the real foundation is the Treaty of Amsterdam, 1997, which established an area of freedom, security, and justice. At Tampere, following the summit of Tampere, things became serious. It was in 1999, and there we decided that we had to lay the foundation for, quotation, genuine European area of justice, progresses, based on mutual recognition of decision. This we shall see further. After that, there was the creation of Eurojust. Eurojust, you know, is a cooperation organ between the various public ministers, the prosecutors of the European Union. But that doesn't mean that there were already an organization of public ministry in Europe. The great step was the step of the creation of the European arrest warrant. 2002. It's very interesting. Why? It was adopted in June 2002, but presented first in the autumn of 2001. For one reason. A, its origin. The various members of the European Union felt that confronted with terrorism, they had, this time, to use the principle of recognition of decision rendered by one judge of the Union in another part, another state of the Union, without using the proceedings too formal, sometimes hazardous, and anyhow far too long of exequatur. The warrant, I want you to realize what it means, because most of Europeans don't know it. That means that if a Spanish judge decides that this man should be arrested because we have already strong indication that he's part of a mafia réseau of trafficking of women, should be arrested in Berlin, he sends the warrant, and the man is arrested in Berlin without any political intervention and given over to the Spanish authorities in less than 40 days. This is a great step further, a great step ahead. Remember what the old habeas corpus stand for. The habeas corpus, you should not be arrested except on due order of the law. And it's, as you know, the fundamental principle everywhere, in all countries respecting the rule of law. Here, the warrant of arrest does not express the will of your justice. It's another justice who decides that you will be arrested. and transferred. The control is only legal, not political. It was necessary. I will not go into details about the problems we had with the German Constitutional Court, but it works now. And there has been a series of steps forward, detail of which I will not go in because I don't think that you would appreciate these details, from 2002 till 2010 in many, many fields: financial penalties, confiscation orders, probation decisions, recognition of custodial sentences, establishment of European Criminal Records Information System, etc., even proceedings in absentia. The Treaty of Lisbon, I stress it, has improved the ways of having European justice progress, because pillars have been suppressed, and now we can go further ahead by using simply, if I may say, decision of the Council and parliamentary decision rendered at majority. This will help us greatly. There we stand now. Why don't we go further? And what are the steps now to be taken? This is, I would say, the projective, if not unfortunately creative, part of this lecture. I said we need a European justice. Nous avons besoin d'une justice européenne. But when you look at the conditions satisfactory to really implement, to the safety of the people, to the safety of the Europeans themselves, this European justice, one should realize that justice rendered under the control, of course, of a supreme jurisdiction, which will be a special chamber in Luxembourg, that's no problem, by the various jurisdictions of the national states inside of this European espace. These justices should answer, satisfied, three conditions. Three. The first one, those various jurisdictions of the 27 countries, they must share the same fundamental democratic values. Otherwise it won't work, and we don't want it to work. We have that. We have that because, thanks to the Lisbon Treaty, the Chart of Fundamental Rights has no legal value and can be enforced. La Charte des droits fondamentaux is our declaration of rights. And as all the members of the unions have ratified it, and it has legal value in all the states, we have the fundamental values, the same ones, everywhere, under the control, may I remind you, of the European Court of Justice in Luxembourg. Shall I say that, without going into details, the fact that the European Union will become a member of the Convention of Human Rights, and therefore will be submitted, I'm speaking of the Luxembourg Court, to the final authority of the Strasbourg Court in order to have a unified protection all over the Union and all over Europe by the European Court by the Strasbourg Court, will be a great final progress. But I must tell you, this is probably the most entangled question that was ever raised among justices in the whole of Europe, and we are working hard to try to solve it. You will see it. I'm afraid I will not see it, so long it takes to really go into the details of the mechanism. I will not go further. That will be the theme for another lecture next year. But, apart from the fundamental values, citizens should find in the courts the same guarantees of their rights, not only judges sharing the same values, fundamental values, but the procedures which guarantees that these fundamental values will not be violated during the process of law. Therefore, you need harmonization of these systems. Harmonization, I wouldn't say uniformity. I do know that I will never convince our English colleagues that they have to give up the wig. They would rather dismiss the case. So no problem whether you have wig or no wig, and whether you have the gown or not gown, whether it's yellow or red or black, that's no question. That's the artistic part of it. But the guarantees of the proceedings should be there. And as I say, we have them through the legal control now by the Court of Luxembourg that the Treaty of Lisbon is respected, and of course by the European Court of Human Rights. So we have that guarantee. Then perfect. But there's the third problem, and this is more difficult to settle. In order to be confident, in order to trust, which means giving up to judges of another country power to decide over cases which do interest your citizen, you have to trust the judges themselves. Et c'est pourquoi it's so difficult. C'est la confiance in the legal capacities and full ethic, moral, and of course financial integrity. You need, in order to say, agree, warrant of arrest here decided will be executed in my country, and my citizen will be transferred to the other country by decision of this judge. You need to be sure that he or she is competent, that he or she shares the same value, that he or she is submitted to the same control, and that he or she is not suspected of corruption. Confidence. The Luxembourg court, in a great decision of 2002, said very, very precisely, in order that recognition, that mutual recognition of decision work, it needs confidence in each other jurisdiction. And it refuses in one case because of that. So how? How this confidence? In this respect, competence in terms of legal knowledge can be ensured. I think we have already excellent formation in our universities. We have already in Florence, the European Institute, we have in Treves, German Institute. We have already institutions, but I think that we should bring together and raise up together the judges who are concerned with the application of European law, are specialized in European law, they should, all of them, get together for periods of formation, of training and confrontation in one an Institut of Higher Studies in European law, an Institut des Hautes Études Supérieures en droit européen. First of all, they would get together. B, they would share the same courses. 3, they would confront their views. And 4, they would therefore belong really to the same culture, same school. Very important. For judges already. They also would be requirements for an ethic code for all judges belonging to this space. Alors, bringing together these requirements, you come to one conclusion. And the conclusion is this. Europe, the European Union, has 27 members. I don't think that in the coming years, I would not even say months, the coming years, we shall reach among the 27, and for all the 27, the trust in each other's justice and justices that is required. There are gaps. And unfortunately, il y a de la méfiance, distrust. Something that only their justice is justice. Something that somewhere here and there might be political motivation for judicial decisions. Something that here and there, in Europe, all judges, not all, double L, judges do not present the full guarantees yet, because it will come required. There is an answer, technical, because we have to be practical. This is an important matter, decisive matter. In the Treaty of Lisbon, as you know, there is possibilities of the coopération renforcée, reinforced cooperation. 9 states, 10 states for a special object. It's exactly what we should use for justice. Like we have started with Schengen, and it has enlarged, we should start at 10 or 12 countries, states, trusting each other because they know the justice of each other and they have a very important current of exchanges and decisions, and start building among these 10 or 12 states a judicial cooperation. The Treaty of Lisbon has made it far easier now to realize it. And it can easily be improved, easily be enforced. The only thing is to get together the 10 or 12 states. I have taken the pilgrim, la canne du pèlerin, and I go from one chancellery to the other and from one government to the other, pleading that this coopération renforcée in the judiciary should be the next step. The question always comes, with whom? I will not give the list, but it certainly should not be a list confined to the countries that a notorious Minister of Defense of President Bush called La Vieille Europe. Frankly speaking, I think that the whole of Europe is rather old. Nous sommes tous tous des citoyens d'une vieille Europe, très vieille Europe. No, we should be careful that it should be in the coopération renforcée states from the western side and from the central and eastern side. Among the 10 or 12, they should be a group of those, they should be a group of 12 with this large scope, not the founders. No, too easy. Together. As I say, there's only one Europe. Doesn't mean that they are all ready to get into the same space, the same system of unified European justice in a part of Europe, but it can be done à travers la coopération. There's one advantage more to it. In the treaty, there is a provision which allows, if there is a cooperation, reinforced cooperation, to use the common institutions, and therefore we can use Eurojust and make it a real united prosecutor for this coopération renforcée. Not that Eurojust will be the actor in all states. It will be the leader. It will be the one who will start, initiate, impulse the prosecutions. Then afterwards, it's the national institution which will work hand in hand. But it will be united and will have the power in the field of course, European legislation and European crimes to bring all the necessary prosecution. And that will change things, believe me. When I think or when I know what's going on about international corruption or those type of trafficking, the necessity of having a body, a European prosecutor, is more necessary than ever, more clearer than ever. Voilà. Alors, when will it be done? Soon. Soon, if you want it. Soon. The only problem is to convince. The only, il n'y en a pas d'autre, advantage of a certain age is that it gives you a prospect. Vous réinsérez dans la perspective. I started in the legal field more than 60 years ago. And believe me, the only idea of a European justice would have made the best minds about our colleagues laugh. Une justice européenne. Et quoi d'autre encore? C'est comme ça. It exists. I have heard Mrs. Thatcher, who was eloquent, but not too European, about a decision rendered by the European Court of Human Rights on the treatment of detainees in English jails, detainees belonging to the era, saying that she will never accept decisions of cosmopolitan judges. I quote. That was a big fuss. She, with all a stern temperament, had to explain 2 days afterwards in the Commons that she was misunderstood. And cosmopolitan judges refer to international culture, not to origins. Nobody wanted to go further, mais ça existe. Ça existe. Today, we have a system, as I said, in Europe, that nobody would have dreamed of in the late or early 50s. When I go to Strasbourg, and I go often to Strasbourg, and I walk into the audience room, I said to myself, well, we have not been complete fools nor useless buffoons. Nous ne sommes pas été des bouffons. We have just seen ahead. As I say, and this will be my final recommendation, look forward. And as legal minds, always try to see what will be the answer, not only for the present conflicts or threats, but for tomorrow conflict or threats. And do it. Thank you.